Hi, my name is Jason Perkins. I'm a Georgia attorney. I focus my practice on helping injured workers with their Georgia workers' compensation claims. Today I want to talk to you about a topic that comes up in most workers' compensation claims, and that is returning to light duty work after an injury. What happens a lot when you're injured at work is that you may miss some time from work, and your employer may pay you temporary total disability benefits for the time that you missed from work. Those benefits are your wage loss benefits. It's essentially lost wages. But after you receive those benefits for some time, your doctor may say that you're able to go back to work. And the question will come up as to whether your employer has any work available that you could do. Now, if they don't, you may continue receiving temporary total disability benefits. But if your employer has work available for you, they may offer you a light duty job. So Georgia's workers' compensation system has a system for how the light duty job should be offered. It's called a Form WC-240 process. Basically what it says is that your employer can go and offer you a job and get it approved by the doctor and then send you a form notifying you that the job has been offered and when you should return to work and what job you'll be doing. It'll also have a copy of the approval from the doctor with that form. And when you return to work on light duty, you get basically a trial period in order to attempt the job. And if you attempt the job for a certain amount of time, at least a day, but less than 15 days, then when you come out of work, your employer or their insurance company will automatically have to restart your temporary total disability benefits. This is basically protection for you to give you an opportunity to try the job and see whether you can do it or not. It is important to understand that even though they have to restart paying your temporary total disability benefits, your employer or their insurance company can still argue that you were capable of doing that job, and they can go to court and try to get your benefits stopped when you say you can't do the job. It's also important to understand that your employer is not necessarily required to use this Form WC-240 process to offer you a job. Your employer can come in and just offer you the job directly. They could call you up or send you a letter in the mail notifying you that they have light duty work available, even if they don't get the job approved by the doctor. Now the rules are a little bit different and confusing in this situation, and it's difficult to get into them all here, but basically the difference in this job offer is that your employer may not be able to suspend your benefits immediately if you don't show up, but they can still go to court and get your benefits stopped. So it's important to understand that you still may need to attempt the job even if your employer doesn't go through the Form WC-240 process. I think it's a good idea that whenever your employer is offering you a job, you should certainly talk with your attorney about it if you have an attorney. If you don't have an attorney, this would be a good time to get a free consultation with an attorney who specializes in workers' compensation law. If you've got questions about that issue or any other issue about workers' compensation, I'd certainly be happy to talk to you. You can set up a free consultation with me either by calling me at the phone number that's on the bottom of the screen or by reaching out to me through our website, perkinslawtalk.com. I hope you found this video helpful today. If you have, please let me know by giving it a thumbs up on YouTube. Thanks for watching.